Hi, everyone. Good afternoon. Thank you for joining us. I see a few people loading in, so I'll just give it a second. Hi, everyone who's just joining us. Thank you for coming in on our webinar. Okay, great. It looks like mostly everybody's on, so we can go ahead and get started. Thank you, everyone, for joining us for our webinar. Today, we're going to be covering real estate and your estate plan. We are presenting Merhab Robinson and Clarkson. We do estate planning and business law. We help with probate, trust administration, entity formations, and employment law. Paula Aragone is also joining us from Aragone and Associates. She is ranked in the top 1% of real estate agents nationwide and has over 800 successful transactions. And so this is a little bit about Paula Clarkson and Paula Aragone. Paula is Clarkson is a managing partner at Merhab Robinson and Clarkson and has more than 20 years of estate planning experience and an LLM in taxation. And Paula Aragone is the CEO and founder of Aragone and Associates at First Team Real Estate. She has more than 20 years of experience in real estate industry and is an expert in assessing value and the profit. So without further ado, I think I'll go ahead and let them take it away.
Thank you, Melissa.
Thank you.
Paula Clarkson. I'm going to go ahead and get started and talk about some of the issues with holding title to your property that you have. And these are really specific to California, as we don't practice outside of California. Some of the theories hold over, but some of them may not. So if you hold property in a different state, then we need to look at the rules regarding those states and how their requirements are. So first things, when you pass your assets at death, there's lots of different ways to pass your property, your real estate. So we can do it by operation of law, meaning that you've left it in trust for a joint tenancy. California is very specific to community property. We do recommend that you put it in trust. This webinar is not related to formation of trust, but we do have a webinar from April entitled Estate Planning 101 if you want to learn a little bit more about that. Other assets you can also transfer as employee benefits and things like that, but those don't really apply to your real estate. For today, we're going to focus on the joint tenancy, community property, and the trust methods for transferring your real estate. So a lot of times I'll get couples that'll come in and hold their asset in joint tenancy. And joint tenancy basically just means that two or more people own the property. And if one of them passes away, then the surviving tenants receive the asset without going through probate. There's no transfer. It's just an automatic transfer based on the deed. And for a lot of people, this is a really good way to do things because we don't have to deal with the courts. You don't have to get a trust. But there are some problems if there are more than one property owner. And for ease, I'll just say like a couple, and they own it together. When the first person dies, that's great. It transfers to the survivor. But then when the survivor dies, then we have a problem with there could be probate at the survivor's death. We also have some potential problems with distribution. Say, for example, Melissa and I own a property as joint tenants because you don't have to be married to own joint tenant assets. And I pass away, it would automatically go to Melissa, and then she gets to choose where it goes. So I lose some control if, I wanted it to come back to some of my family members or beneficiaries. Also, we have a problem that there's liability shared because we want to make sure that, if Melissa has any debts or creditors or somebody that come after her, they could potentially come into the property. So that could be an issue and they could attach, and I own an undivided interest in it. So it could have a significant impact on me. Also, we have an issue that if I were to become incapacitated in this example, Melissa cannot refinance the property. She can't sell it or do anything like that unless I were to give her separately some type of power of attorney or legal ownership. So while it can avoid probate, it's not going to avoid issues regarding my incapacity, which would require a conservatorship to be open to give her those types of powers to deal with that. Also, when someone passes away in California, or really in the United States, their assets get what we call a basis adjustment. So, for example, if we bought a piece of property for $100 and we're able to sell it for $1,000, normally the difference would be subject to capital gains. But when someone passes away, their portion of the asset gets a new basis. So in my example, if Melissa and I own a property together and we purchased it for $100, my basis is 50, Melissa's basis is 50. If I were to die, then the property only gets a basis adjustment on my half, not on Melissa's, which definitely would help. And in our example, my basis would now be $500, or, after I pass, Melissa's would still be $50. And if she sold the property for $1,000, the difference between $1,000 and the $550, the new basis, would be subject to capital gains, subject to some other issues that we're going to talk about in a bit, depending on whether it is your personal residence or a rental property. So when you have spouses, this could be a very significant impact on how to hold the property. So California being a community property state, we have some additional benefits. Instead of holding property as joint tenants for married couples, we prefer that the title to be held as community property with rights of survivorship. So just like joint tenancy, the property will go to the survivor of the owners. So, but in this case, I cannot own the property with Melissa because we're not married. I would have to own it with my spouse. We would be listed as community property with right of survivorship. If I pass away, then my husband gets the property, and vice versa. The difference, the biggest difference between community property with right of survivorship and joint tenancy is that when you hold it as community property, it doesn't matter if one person dies, 100% of the basis gets adjusted. So in my example before, that if Melissa sold the property after our death, she could be subject to $450,000 at capital gains rates. In my example, if I own that same property with my spouse and only one of us died, the basis would be reset to that $1,000. And my spouse could sell the property after we died for little, if any, gain based on the basis step up. We still do have some of the same issues of what happens when my spouse dies. There's the potential for probate, disinheriting my beneficiaries, as well as if one of us is incapacitated without any other authority, then we cannot sell the property, rent it, refinance it, all those types of issues. So it's really important that we look at how we title property in California. And especially, when we do put the assets into a trust, which avoids the probate altogether, it avoids the conservatorship, because the trust provides all the terms of what happens during incapacity and death. We will often prepare deeds when the client, a married couple, comes in and they own it as joint tenancy. We will do a two-step process and transfer it from joint tenancy to community property with right of survivorship, and then community property into the trust, so that it's confirmed that it is community property, so that they will get those basis adjustments. And again, this is also subject to the property actually being community property. We have lots of married couples where one or both of them may own some separate property real estate, and that has other issues because again, if only, for example, my husband owned a property as his separate property and then died, then only because he is the sole owner, it would get a basis adjustment. But if I owned another property, a separate property, and my husband died, because he has no interest in my property, there would be no basis adjustment. So we really have to look at the pros and cons of, do we own it as community property? And that does affect issues if the marriage were to end, and how the assets are divided at that point. So sometimes you're looking at, for the most part, we believe that community property with rights of survivorship is paramount to joint tenancy, but in certain instances, keeping the property as your separate property is a better thing. We also want to look at, when you have rental properties or properties that are not your primary residence, we generally recommend that you put the properties into an LLC. Your LLC then would be owned by your trust to avoid probate and so forth. The LLC is just, a limited liability corporation created under California law. And the benefits of doing that is that if there was some issues on the property, let's say an electrical fire or something, and the LLC, the property gets sued, then the most that the liability to me would be the assets in that LLC. So that's a good protection on my other properties. And generally what we'll do is try to only put one or at the most two properties, especially depending on their values, into an LLC at a time. So, if I own 5 rental properties, I'm not going to put all 5 of my rental properties in one LLC, because what happens is, if there is that, electrical fire or something on one property, then it exposes all of my other properties to a potential lawsuit. Where if I only had that one property in an LLC, the most they can take from me is that property, which really helps. It's also a great way to have centralized control over the property. You can even put different limitations in the LLC agreement on who the property can be transferred. So for example, if Melissa and I went in on a rental property, it'd be a good idea to put it into an LLC. We would each own our 50% in the LLC, but I may not want Melissa to transfer the property to her husband or to her children, because maybe I don't like them or I don't want to be in business with them. So then we can build in things into the LLC on where that property can be transferred, if I have a first right to purchase her out, different things like that. We also can play around with discount valuations, because if I only own 50% of it, there's a certain amount of lack of marketability on that property. So when I pass away and we have to value the property for estate tax purposes, then on $1,000 property, I don't really own $500 with a discount valuation. It might be valued at maybe $350, $400, so that I can owe less in estate tax liability, because there is a reduced marketability and transferability on a minority interest. It also allows you to hold property and have some privacy. I don't necessarily want people to be able to look up and see all the properties that I own. However, if they're titled in the name of an LLC, it gives me some privacy. It also means that my tenants don't necessarily know that I'm the one that is the owner of it. It's the LLC, that's who they write their checks to, that's who they have the lease agreement with, and so forth. So it gives me some anonymity and to get away from them. I mean, with anything, there's always cost and downsides. When you have an LLC, obviously there's a cost to create it. There's unless it's just you, a single member LLC, you're going to have an annual tax return. In California, we have a franchise tax fee of $800 annually. And then there's also a gross receipts tax. It's based on the revenue of the LLC. So, those are things to look at. A lot of my clients will say, okay, the $800 fee to the franchise tax board is not a fun thing to pay, but you have to kind of think of it as an insurance policy of, I'd rather pay that every year and limit my liability and exposure to my other assets. Also, sometimes when you have the property in an LLC or, these limited protected entities, there might be some less ability to borrow on the properties. And if you already have the property, So say Melissa and I already own a property together and we have a mortgage on it. We can't just go create an LLC and put that property in there. We have to get approval from the lender, or there's the possibility that our loan could be called. So whenever you have a lender involved, you need to look into what are the ramifications. There's lots of lenders that will approve it. We just need to get that in writing and confirmed from them. And there are lots of lenders that will loan, but in order to get that protection, sometimes they're going to charge a little bit higher interest rate. Again, it kind of comes back to, you're paying for the extra protection that you're going to get. We also had some law changes in the last few years regarding transitioning property at your death among parents and children specifically. It used to be that basically parents could transfer their home, their residence of any value to their children, and their children would keep the property taxes. And then there was a specific amount of non-home property, you're outside of your personal residence, that could be transferred and excluded. And most of that was taken away with Prop 19 that took effect in 2021. Now, if a parent transfers their real estate, their residential home that they live in, to their children, the children have to move in and make it their personal residence within a year of the death. And then the child is limited to a portion of the property value not being reassessed. So, for example, if we had a $1.5 million property, that's the fair market value. But because the parents had purchased the property, 30 years ago, maybe they purchased and are paying current property taxes at a rate of, say, $300,000. So their original tax assessed value is 300. Then the next million gets excluded. So we have $1.3 million of value of the property that would be subject to property tax at $300,000 limit, which is really good. But in my example, the property is worth 1.5. So the difference of the 200,000, the children would be subject to reassessment. So instead of getting the property and keeping mom and dad's property tax basis of 300,000, the children would now have to pay property tax on a basis of 500,000. It's still a pretty good deal when you're considering that if the children were to go out and buy a house that is valued at 1.5 million, they would be paying property taxes at 1.5 million. So they're paying more than mom and dad, but they're still paying a lot less than they would have. So, again, it helps us, but not always as much as we would want. And it only applies to the parent's personal residence. Any other properties that the parents own, whether it be, residential rentals or commercial rentals or property, then those are fully subject to reassessment when the parent passes away. So that's something that the kids would have to take into consideration on whether they're able to keep those properties or not. And so that's where excluded. Prop 19 gave some good benefits to people that are 55 years and older. It used to be that if you had someone in that age group and they sold their house and moved to another house, they would only get to keep the property tax one time. But now you can move up to 3 times, and you can move anywhere in California. So this helps when you have, as your parents, get older and maybe they want to move closer to a child that, for example, maybe the parents live in Southern California, the child is settled up in Northern California, and the parents are concerned that their property tax currently is at a very low amount, that if they were to move up to Northern California, that their property tax would skyrocket when they purchase a new property. So there is an exclusion form, and the easiest way is if you buy a property for the same or lesser value, then you keep your same property taxes. But if you were to purchase a property that's a little bit higher in value than your current home, there's a formula on paying the difference. And so, but again, we're looking at up to 3 times the value. And oftentimes, at that age group, the parents might be downsizing. So the property value may not be higher. So you have to look at the new cost of the new home and so forth. And there are documents that need to be filed with the county to make sure that that rate is maintained. But it doesn't apply if you were to move outside of California, because every state has their own rules about property tax transfers. In some cases, the parent-child exclusion, we will use LLCs as a workaround. One of the benefits also of LLCs is that when you have two owners, for example, let's say Melissa and I both own the LLC, and let's throw Paula in as well. We each own a third of it, so 33%. If Melissa were to transfer her interest in the LLC, then to, let's say, her husband, then he gets to keep the same property taxes, or she transfers it to her daughter. Her daughter gets to, the property taxes for the LLC stay the same. It's not until the three of us as original owners transfer more than 50%. So if Melissa and Paula were to pass away and they both transfer their interest, even if they died years apart, when the second of them dies, we have now reached more than 50% being transferred, because together they own 66%, and we have a property tax trigger on the whole LLC. But there are ways to get around. We've seen some clients that we can put in. Let's go back and say that it's just Melissa and I owning the property. Then she can give away 49%. Okay, now we're to Paula. So I own 50, Melissa owns 1, Paula owns 49. And then at a later date, maybe we dissolve the LLC, because this makes a difference with the LLC. Now we each own it in our individual names. And if Melissa now transfers her 1% to Paula Aragone outside the LLC, that 1% interest is going to be subject to property taxes. So that's fine. And now the owners are me and Paula separately as individuals. Now we go and create our new LLC. And with the new LLC, we are now 50% owners. As the original owners of this new LLC, our rules start again. We can transfer up to 50% without causing a transfer of property taxes. So I can pass away, leave my 50% to my children, and there will not be a change in property taxes until a later date when Paula changes. So there's ways that you can go in and out of the LLCs and take advantage. And in our example, instead of having Melissa's 50% of the property tax reassessed, we were able to limit it to 1%. So there's a lot of different ways to kind of get around it. If you have significant property of value with a low property tax basis. So give us a call and we'll be happy to kind of walk you through and see if these methods are beneficial to you. Because in some cases, the property taxes are just going up too high, and it's really cost prohibitive for the kids to be able to continue keeping that property. So now I'm going to turn it over to Paula, where she's going to talk about, how we sell properties, whether they're going through probate or if they're in a trust after a loved one passes.
Yes. Good afternoon, everyone. So selling properties through probate and trust. Probate is a little bit more complicated than selling properties through trust. When you have a loved one that passes away and they don't have a trust in place, which is what Paula Clarkson was referring to, set up your trust so that you are protected. Now you have to start the probate process. Takes a long time, takes 2 to 4 years to go through probate. So it's not something fun. There's lots of cost involved in that. And so we will be able to assist somebody that is going through probate process to get them to sell the property, maximize the sales value, and for the benefit of all the beneficiaries, obviously. We sometimes have 22 beneficiaries on a probate. It's a very tedious process. You have to really need guidance from an attorney, and people that know what they're doing. It's not easy to sell probate properties. Absolutely can be done, but it requires more knowledge and more experience. And that's why we've been doing this for over 20 years. What we do when we get a probate property, we assess the value of the property in its present condition. We understand when we're getting letters testamentary and when the administrator can start the process of selling the property and what needs to happen so that they can maximize their sales price and end up with a bigger net. Our goal is to get everybody to net more money than if they were to put the property on the market in its present condition. So one of the things we do, we go in, we look at the property and we say, okay, if we were to sell the property in its present condition, this would be the price. We present it to the administrator, review what would be the options and the return on investment if we were to do X, Y, and Z. So then decisions are made, and obviously the process takes longer. There's sometimes, notice of proposed actions, things that the attorneys will help you with. When it comes to selling property in trust, it's a lot simpler. Obviously, there's still, precautions that we take to protect the fiduciary responsibilities of that executor or administrator or trustee. And we take those precautions seriously. We try to complete those disclosures that go with the sale of an asset in the best possible way. And we have an addendum that we've used throughout the years to assist our clients with removing liability. So very, very important to know that you have fiduciary responsibilities, and as agents are going to guide you to not incur in any more than what you need. Okay. So then we go into the process. The process on a trust is very simple. You don't have to wait for, letters. You can basically sell the property the next day that, your loved one passes away. Now, one of the things that we talk is when somebody passes away, let's say a spouse has died and the other one is left with a house with a lot of equity and they're not in a good place to sell the house. Obviously, you're dealing with the loss of somebody. You can't tackle immediately selling that property, although it might be, an emotional decision. You're not in a good place to make that decision. So we give them options. The options sometimes come with, taking a reverse mortgage to gain that access to the instant equity that you have in your home. So let's talk a little bit about reverse mortgages and what they are and how they can help somebody. So a reverse mortgage is basically a financial agreement between the owner of the property and the lender that will allow homeowners to convert the equity they have in the house into cash. So basically, you're going to reach out to the lender, say, I want a reverse mortgage. You're going to analyze the benefits and the cons. We're going to talk about those in a minute. And then you're not going to make mortgage payments. You're basically going to write checks out of your property, of your equity, so that you can support your living style, whatever those needs might be, right? So how it works is the lender will give you money tied up to the equity of your home. There's a formula, loan to value, that they will give you. Average is 33 to 55%. It depends. Lenders want to be very, very careful that they're not going to give you so much equity that as you are eating it away, now you end up on a short sale situation where you owe more than the property's worth. So they're very careful with that. They will also want to see reserves, bank reserves, social, 401ks, whatever the case might be. And they also want to make sure that there's insurance in the property and the property taxes are being paid and there's money for that. So that is what a lender will take into account. They'll give you 33% to 55%. So for example, you have a property that now you bought for $500,000, and today in this crazy real estate market, the property is worth $4 million. That doesn't mean you're going to get automatic $2 million. They're going to go through the formula, assess the property, get an appraisal, and then they'll analyze your income and your assets, and they will tell you how much they're going to give you. Remember, people that are getting a reverse mortgage don't have stream of incomes because they're retired, they're not working. So it's basically, what you're making out of your investments. So they'll give you that money, you'll start using that money. What are the benefits? Very simple. Being able to stay in your house while you make decisions if you want to sell or not to sell. Support your living expenses. That could be in-home care. That could be to offset some other costs. That could be for improvements on the property. Many reasons people get reverse mortgages. Now, what are the cons of reverse mortgages? Basically, the downsize is the high cost. You have really high costs. Reverse mortgages come with loan origination fees, high interest rates, closing costs, mortgage insurance premiums, lots of things that make them costly. Second one is there's interest accumulation. So remember, you're not making payment. So your interest is compounding and it's growing the amount of interest, and hence it's reducing your equity. So as interest accrues on the loan, on your loan balance, the equity gets smaller, okay? Then the next one, because of that, is the reduced inheritance. A lot of the times, by the time the beneficiaries get, the heirs get the property, there's very little equity because it's being used by mom and dad to offset their living cost, which is fine because that was the intent. That was the reason they took it. So by tapping into the equity of the home, borrowers are diminishing the value of the equity on the estate. And then the next one is the risk of default. You have to understand that property taxes need to be paid, homeowners insurance need to be paid, the maintenance on the house has to be taken care of. So if these things don't happen, the lender can force a default because you're not paying your property taxes, you're not paying your homeowner's insurance. So that could be a potential problem, especially after, the homeowner passes away, if somebody's not maintaining, paying those bills. So those are the downsides. Now, it does happen, a couple of other things that I always tell my clients, you need to pay attention to this. Government, impact on government benefits. Sometimes people don't understand that by pulling money from a reverse mortgage, you might be impacting the benefits from Medicaid or supplemental security income. So that's important to consider before getting a reverse mortgage. Make sure you talk with your advisors. Then the complexity and risk associated with this. This is a financial product and you need to understand it. And I always say, if you need help with understanding before you commit to getting a reverse mortgage, it's crucial that you bring your advisors so that they can assess and help you make that determination. Third one is it's non-transferable. So let's say you take a reverse mortgage on this property and then later you decide you want to sell that house and downsize and get another property. You can't just transfer it. So you're going to have to pay off that, moving to the new property and start the process all over again, okay? And sometimes what people don't understand is that by having to qualify for a reverse mortgage, having to have that, loan to value and those reserve assets, sometimes people don't qualify. So it's better to plan while you have assets than to wait until your assets are depleted and now you don't qualify for a reverse mortgage. So plan ahead, don't wait till the last minute. And then the limited access to that equity. Again, 33 to 55%. It's not that you can get every penny that you have on the equity in your home. So things to consider before getting one. Now, again, we provide our clients options. One of the options is to tap into the equity of the home. The other option that we offer them is called downsizing with distinction. And we're going to talk a little bit about that because it's a really, really good program that we've developed throughout the years, because we realize that sometimes we go into a property, let's say parents own property. They've been living there. They haven't told the kids that, they can make ends meet every month. So they're living on a fixed income. They haven't been changing the carpet or keeping up with the plumbing or, painting, things like that. And all of a sudden, the house is becoming too much of a burden and an expense. Maybe the house is too big. Maybe the house has stairs and they can no longer, live in a house with stairs. So what we do is we create a plan called downsizing with distinction. And you can decide what you do with the money we get you after you sell. So we would, again, go into the property, look and assess the property for its current value on its present condition, and find hidden value or hidden profit that we can tap in by doing strategic improvements. So maybe we go in and we see that house has tremendous potential, but the carpet is the old carpet. The bathrooms haven't been updated. The house has popcorn ceiling. So we're going to create what we call our wish list. We're going to go with a contractor, make a list of all the things that could improve the value of the property. And then we work with those based on return on investment. So if we do X, Y, and Z, this is what we would expect to get versus if we do nothing or if we do, A/B only. We give them options and then we go ahead, we do the improvements. And when we sell the property, our clients end up with hundreds of thousands of dollars more. I mean, our success ratio is incredible. Our clients get minimum $100,000 over, and we've got clients that we got 500,000 over. So additional net after we did the improvements. So what do people do with this additional net? Two things. One is if they're looking to downsize into a smaller property, they can go ahead and use it as a down payment. Now they have extra cash to put in to be able to keep a low payment or to basically pay it off. The other one is sometimes they want to rent. We just did a property that Paula Clarkson was assisting the client with the trust, and she brought us in the case. And this lady was 91 years of age, and the house was 10,000 square feet. We help her sell the property, maximize, and then she rented. Now, in this particular case that we have here, Melissa, if you can go back one slide, we'll show you what we did for this client. This client was in San Clemente. They were going through a health issue. They needed to be closer to the hospitals in Irvine. The house needed a lot of work. We had a green kitchen, as you can see, and old flooring, and they didn't have money. So we went in, we devised a program that was $60,000 worth of improvements. We painted the kitchen white, put brand new luxury vinyl flooring. And we can go to the next slide and you will see this was their bathroom, red bathroom, not upgraded. We turned it into a beautiful white bathroom with very little expense. This client, by investing $60,000 of our knowledge, our coordinating with contractors and all the work we did, was able to net an additional $130,000. 165,000, and they ended up walking away with a 1.3 million. So the property in as-is condition was 1.9. The property after repair, 60,000, sold for 2,215,000, and they netted all this additional money. They moved closer to Irvine. They were able to be close to the hospitals, and they didn't have to maintain the property. They didn't have to pay property taxes. They didn't have to pay property insurance. They rented closer to the doctors. So that's why we say we can customize a program that works for each individual needs. Could be downsizing into a smaller home. It could be moving into a rental. It could be moving into an independent, care facility. There's many options for people that are now living in a very big house that doesn't fit their needs anymore. So those are the things that we do when you engage Aragone and Associates. We sit down, we take a very big approach into what's the best for our clients, and we consult with advisors, estate planning attorneys like Paula Clarkson, and we collaborate in making the most out of what we have at hand.
Thank you, Paula. So we're basically just trying to show you that depending on how you hold title, there are different pros and cons. We want to make things as easy as possible for you to be able to transfer your property either during your lifetime or upon death without incurring unnecessary taxes. There also, we wanted to make sure that you're aware that there's a lot of different options available to you, either during life or after you pass away, regarding, options to stay in your home, options to reduce the value, sell your home and buy a home that may be smaller, saving property taxes, and even dealing with it after you pass away, so that your heirs can net the highest value as possible for the transfer. So, there's no one size fits all, but we just want to let you know that there are so many different options available, and that you don't have to stress about what you're choosing and how it affects your family. So we'd be happy to answer any questions that you have.
Yes, please go ahead and put any questions you have in the Q&A feature. It looks like we have a few lined up already. And if you have any technical problems, feel free to just throw them in the chat and I can go ahead and address them. So I'll just get started with one of the questions that we received was, upon the death of an owner of an LLC, what is the implication for the basis?
So it's called a 754 election. It basically it will get a basis adjustment as well, but because it's an entity, it's something that your accountant will have to file with the tax returns, but it will get a basis adjustment. Everything that a person owns when they die gets a new basis adjustment, other than outside of retirement type plans, IRAs, 401ks.
Great, thank you, Paula. Somebody else asked regarding Proposition 19, if there are 2 children in the family, can only one child make his or her personal residence and keep the favorable tax reassessment, or would the property only see half of the favorable tax reassessment?
It just has to be one of the children. In most instances, it'll be one of the children will take it. Maybe the other one will take some other assets to equalize it out, or some mixture of the both. I actually do have one client right now where there are 2 children and they've chose to keep the house and move into the home with their spouses and live there the rest of their lives. So that's working out quite well for them, but it does only take one child to move in for the parent-child exclusion to apply.
Love that. Somebody wanted to know, somebody asked a question and I'll answer this one, is if we'll be providing a recording of this webinar, and yes, we will be. We'll post it to our YouTube where we have lots of our webinars up there for any information. But moving on to the next question, they wanted to know if we could clarify again the optimal title for home ownership for married couples, titling their home in the name of the trust versus community property.
Yeah, so if you have a trust, then it would not be titled as community property. We would title the property in the name of the trust. But in order to confirm that you do want that double basis step up, before we put it in the trust, the title would be transferred from joint tenancy to community property and then into the trust. So ultimately, title upon your passing in the name of the trust is best to avoid probate, also deal with incapacities and so forth when you pass away. And because the property has been deemed to be the community property, you'll get the 100% basis step up, even holding the property in the trust.
Excellent. And we got another question about if a property is in probate, do you pay taxes on the property?
Yes. So it depends on what taxes you're talking about. The first one is property taxes. Yes. So unless we can have the Prop 19 apply, so that applies whether the property goes through probate and at the end of the probate gets distributed to one of the children, or it doesn't go, it gets sold. So if the property goes through probate, but in the middle of the probate, the real estate is sold, the property tax would increase from date of death until the date of sale. If you're talking about income taxes on the sale of the property, then we look to that basis adjustment again, and that applies whether the property goes through probate or not. And then we also have, there's estate taxes. In the United States, if any of us die and our assets currently are over $13,610,000, the amount over would be subject to 40% estate tax, whether those assets go through probate or they just go through a trust. So, and that number, the 13.6 million, is to be reduced January 2026 down to 5 million. And then there's the expectation that it will be adjusted for inflation. So end up around 6. We don't have a 6 million per person. We don't have an exact number yet. But yes, there, all of the taxes, income taxes, estate taxes, property taxes, all still apply, whether the property goes through probate or is passed outside of probate through a trust.
Great, thank you. Somebody asked, if you have a primary residence in trust for one child and another property that the second child lives in another state, in the trust, does the tax basis change?
So California has the rule of the Prop 19, then the property that's outside of California, you'd have to look to the laws of that state, because they may have a property tax increase upon the death, or they may have some exclusions like we have. We really just need to look to the laws of that state to figure that answer out.
Okay, great. And then I got another question. What if I don't have the money for the repairs to my home to sell it?
So we do find that not all the time, but often we have clients that are, asset rich and cash poor because, again, they're living on a fixed income. And so they're like, we want to downsize. We like your program, but we don't have the ability to spend that kind of money doing repairs. So we will advance those funds. We will do an analysis, see what's the money we can put into the property that will make the most sense. And we will advance the money and then get reimbursed at close of escrow. So that's a great thing to keep in mind, because sometimes, again, people say, I have the intention, I love what you do, but I just can't afford to liquidate what I have left on my 401k. Right? So yes, we will advance those funds. And then going back to the taxes, is funny. Sometimes we do get asked, so, do I have to pay sales tax when I sell a property? And I'm like, no, there's not such a thing as sales tax when you sell a property. You have capital gains tax. So, always do keep in mind that as a single person, you do have, like Paula mentioned, your cost basis, but then you have a $250,000 exemption. And then you, as a merit, that doubles for $500,000. So, always keep that in mind.
Great, thank you, Paula. Somebody else asked, should the LLC be named in the trust?
Yes. The LLC, the ownership is in what we call the members. So the member of your LLC should be the trustees of the trust. So if it's the Smith Family Trust, that would be, John Smith, trustee of the Smith Family Trust, is your member. Because when you have a trust, we want to have everything that you own titled in the trust so that we don't go through probate on any of those assets.
Thank you. Somebody else asked, if a home owned in California is titled in the name of the trust, but there are multiple beneficiaries, most who reside outside of California, does that mean the home must be sold and the liquid asset be distributed to the multiple beneficiaries?
No, it does not. You can leave your assets to whomever that you'd like. If you have a property, I would think in this example, like it might be a vacation home or something, a beach property or a mountain property, and there's no problem with having multiple owners of it. There's obviously problems sometimes when you have multiple owners of not agreeing and different things like that. That's a perfect place that if you had, let's say, 4 kids and they wanted to keep the property as either a rental or a family vacation home, to create an LLC so that they specifically detail what each of their requirements are. You know, who's going to be putting in the money to pay the property taxes, who, you know, what weeks each one gets to use it, different things like that, who they're allowed to transfer it to. Those are really important things, so that perhaps the property doesn't get transferred outside of the family. So it always just varies depending on the family, if they can all agree. You know, and sometimes the family members will just buy each other out if maybe one or two of those 4 kids wants to keep the property and the other 2 don't. So there's lots of different options.
Great, thank you. Somebody else asked, in an effort to reduce cash assets, how much per year can you give to your children, and is that a good strategy?
Okay. Right now, the federal law says that you can give $18,000 per person per calendar year. So if you have a married couple, so like me and my husband can give each of our children, we have 3 children, $18,000 a year. So technically each child can receive $36,000 a year from us as a couple, income tax free. And then let's say child number 1 is married, we can choose to give $18,000 to that child, income tax free. If you go over that limit, like I gave one child 30,000, like together combined, let's see, 18 is 36. If we gave one child 50,000, the additional 12,000 is technically subject to capital gains in our estate. But right now we're allowed to pass 13.6 million either during life or death. So it just reduces the amount we can pass. We will file a gift tax return and it will reduce it. So we won't be out of pocket at all at this time. Just be able to pass less when we die. The recipient of the gift does not pay any gift taxes at all. You can also avoid gift taxes by paying education directly to the institution, as well as medical expenses. So if you have children and your grandchildren maybe go to private school, you could pay the private school tuition directly to the school. Do not give the parents the money, or else that applies towards the 18,000. You would just pay the private school directly, and then you can still give the parents $18,000 each. And then the same would apply with medical expenses. Pay those expenses directly to the hospital or medical provider to avoid having it applied towards that 18,000 annual limit.
And we have a lot of parents that do that. They help their kids with down payment to buy their house, or their grandkids, by taking advantage of the gift, that they can give. We just had one that our client actually paid the house for the kids. And it's going to reduce, from his estate tax. So, people do things like that. It's always good to plan.
Yeah. In using that example, let's say that my husband and I gave one of our children $1 million to buy a house, then we can give that child each $18,000 a year. So I guess, I don't know, whatever the difference is, 984,000 would be subject to gift tax. But I can pass $13 million gift tax free. So all that reduces and says, well, now when I die, I can pass 12.6 million estate tax free. As long as my estate's below that, I don't really have an issue with it. And it's a way to make a larger gift. But you just got to look at all the different pieces to make sure that it's not throwing you into to different tax issues.
Thank you.
No, do not, but the way to avoid, we have an issue that comes up a lot, is that the parents they think that they are co-signing for their children. And what ends up happening every single time is that the parents are now on title to the property. So because the lender says, okay, you're not co-signing, you're actually being a co-owner of it. So that always ends up being a problem, because they'll come in and I'll go, okay, well, your house is owned half by your parents. And then now we're in a position that they're like, wait a minute, I'm supposed to own 100%. So if the parents then deed you their portion of the property, then it's considered a change of ownership, looks at triggering property taxes, looks at a gift for the parents, and can cause all kinds of problems. So that's something that we'd always want to talk to you about before going into those situations.
I agree.
Thank you. I have a couple of other questions. We are running close to our end time. But somebody asked, if I sell my California home and pay cash for a home in Italy, how do I ensure that my new home is passed to my heirs when I die?
Your new home in Italy, you should get an estate plan there. And it just depends on what their laws are and their requirements. Every country has different rules. So I would just seek counsel in that country to figure out what your options are.
Great, thank you. And then the last question, what if my children are stepchildren? Does that, I think that might have been in relation to the cash assets and
Yeah, well, to the parent-child exclusion, there are certain circumstances that it does apply to. We have to go through a list of questions about, is there other parent alive and different things like that, if they would still qualify or not. So we'd have to look at the situation.
Okay. Okay, we'll do the final question is how much cash can children inherit without paying capital gains if all assets are in the trust?
Okay, that is talking about two different things. Okay, so whether your assets are in a trust or probate or not, everyone in the United States has an estate tax. Okay, and the estate tax is not paid by the beneficiaries in California. In California, the estate tax is paid by the executor if it goes through probate, or the trustee if the asset is in trust. So the best way to hold the property is in trust. Then what happens is upon your passing, the trustee is to value all your assets, determine if your assets exceed that threshold of the 13,610,000. If they do, then the difference is subject to estate tax, and the trustee will have to file the estate tax return before the assets are distributed to the beneficiaries. So the beneficiaries don't come out of pocket directly, it's before it's even given to them. And then capital gains tax are a different thing. So the benefit is because if I were to die and my house is in the trust, I would get a basis adjustment on my house. So if my house is worth $1 million when I die, the basis will get adjusted to $1 million. So if my property is sold 3 months after I die, technically you're selling it for the value on your date of death, and there's not going to be any capital gains tax. So it's just if the property appreciates after I die and it's sold 2 years later, it's the sales price minus the value on my date of death is where the capital gains tax come in. And they are two separate taxes that could be levied at the same time, depending on the situation. And California does not have its own estate tax, but other states do. So one of the questions said, there's a piece of real estate in another state. You always have to then go to look at that state and see if, it has its own threshold for state estate taxes. But luckily, that's one of the only taxes we don't have in California.
Yes. And it's very true that sometimes people don't look at all the assets that they have, including their businesses, because that's part of the exclusion. Sometimes you get all these assets and you're over the 13,610,000, and all of a sudden you're selling a property and the IRS wants their 40% share on that house, and they want their money. So, it happens really quickly that they want their money. And the other thing we always say is upon death, the 6 month is important, because if we put money into a property to fix it, and now we're increasing that value by 500,000, the value at time of death is the sale while it's within those 6 months. So it's very important. If we do it a year later, now you're paying capital gains tax on everything that we put into the house.
Well, thank you both ladies so much for the wonderful presentation today. So sorry, everybody, this is the last question we had time for. Just if you have any other questions, feel free to contact us. These are both of our websites. Again, thank you to our presenters, Paula Clarkson from Merhav Robinson and Clarkson, and Paula Aragone from Aragone and Associates. Feel free to check out our website. We have tons of really great informational webinars up there, and links to our YouTube and our social media, which will keep you up to date on the next one. So everyone have a wonderful afternoon. Thank you for joining us.
Thank you.
Thank you. Bye.
Bye.